and to clear your doubts. So you all are from National Law University, you're studying in National Law University. I'm also from National Law University, Raipur, Hidayatullah National Law University. I was graduated in the year 2010, and my area of specialization is in constitutional law and corporate law. So the journey that I had till now is very interesting, because I come from a very small town, Bilaspur, Chhattisgarh. You might be knowing, because many a time when I tell someone that I'm from Bilaspur, Chhattisgarh, they ask, are you from Jharkhand? So this is one of the challenges that I faced most of the time until the High Court came here. So coming from this small town and from a background, I'm a third generation lawyer. So when I say I'm a third generation lawyer, the first thing that comes to your mind is it must be very easy. See, a third generation lawyer has to become advocate, he has to join that profession. So what are the challenges that a third generation lawyer will face? It would be a piece of cake. You just have to come to the bar and everything will be served on the plate. And that's how you practice. That is the first thing that comes to everyone's mind to whom I introduce that I'm a third generation lawyer. And that's not the case. Because before I joined National Law University, and even when I was in National Law University for the first 2-3 years of 2-3 semesters of my career, so there was one thing in my mind, that irrespective of the fact whether you become a gold medalist, irrespective of the fact whether you get distinction or higher CGPA or a lower CGPA, the moment you have a degree in law, you become a lawyer. That is all is required. I think you all must have heard this line. Are you? Anyone? Come on, speak up. Otherwise, I'll think I'm very boring. Anyone have heard you this line? Someone must have told you that to become a lawyer, you just need a law degree. You don't have to. You don't have to get a gold medal to become a lawyer. So that was the perception I also had initially, and I was going with the same perception. So there were around 55 students in my batch, and when the first semester examination result was declared, I think I was ranked 50. That was the pace with which I was proceeding. Then, interestingly, someone told me that, okay, anyhow, you are going to become a lawyer since you have decided to join this profession. So why don't you study and see what is actually there? I said, okay, to spend some time, let's study. So then we started studying. And I'll tell you one thing. Law is a completely different subject. You may not be aware of this because you must be thinking कि किसी तरीके से पास होना है, we have to join the profession, or we need a particular marks to get the placement. But what is the objective of studying too much for the subject? You know, to study the law and to understand this will completely change your life. Because when you talk to a person and you are well educated, you are well learned about the topic, he will understand that this person knows something. This is the difference that will make. Your thinking, your way, the manner in which you will approach to the profession, to your career, everything is going to change. If you don't believe me, then you must try it. It's not just that you have to study only for the purpose of scoring marks. You have to study to learn. In your batch, in your class, there will be someone who is very, very smart, who don't read, and then he score good marks. He must be very good orator. एक ना एक स्टड तो हो गई आप लोगों की क्लास में. Is it not? Am I correct or not? I am also from your fraternity, National Law University. So I know this fact. So you can give a good reasoning, you can give a good argument, but you cannot give a legal argument unless until you study law. You may be a stud, you may say good things which will impress, but that's a logical argument, that's not a legal argument. And as a legal student, you should understand what is the difference between a legal argument and a logical argument. You may give 10 logics, but one legal submission is sufficient for that. And in order to come to that point, you really need to study. So if any one of you is thinking of opting for litigation, don't think that I have to get a degree to become a lawyer. There is always a difference between a lawyer, a good lawyer, and an excellent lawyer. If I talk about Supreme Court, there are about 8 to 10,000 Supreme Court members, like 8 to 10,000 advocates are registered in Supreme Court. But how many names do you know? If I'll start anyone to count a name, a good lawyer in Supreme Court, how many can you count? I think you'll not be able to reach 100 also. Is it not? What is the difference? What is the difference that makes? Is this profession is only about minting money? Or is it about learning also? Who comes to a lawyer? This is the thing that you have to understand. Who comes to a lawyer? A person in utter distress will come to you. Maybe he's losing job, maybe he's losing promotion, maybe he's losing a property, or maybe he's going to jail. You may read and say that, okay, you have a good case. But unless and until you know the law and you give him a good advice, you'll not be able to save him. And you'll not be able to make out your name. So for that, I studied really hard. And then by the end of the 5th year, even then I was not able to come to under 10. I was ranked 11th because there was too much competition in my class. People really used to read and study a lot. But then the next question that comes to your mind is, what should we do after passing out from the college? Because everyone is saying that only the lawyers who becomes a lawyer are the actual law graduate, and those who goes to a law firm or join an LPA or some corporate, they are the employees. I think this is the perception that everyone has. Even my senior told me and everyone in the class that it is the lawyer who are the actual kings and not someone who's working in a law firm or a corporate. They are the slaves. Have you not heard of all these terms? Say yes or no, bolo haan. Yes, say yes. So, but that's not the case. I think everyone should choose his or her career according to his or her own will and capacity. One has to understand this fact. But I decided to become a lawyer from the very initial stage. Even when I was in school, I decided that I'm going to become a lawyer. So I started practicing in district court. I practiced in district court for about 6 months. And then I joined the High Court. So I worked there for about 2 years. But when I joined Chhattisgarh High Court was only 10 years old because I joined in 2010. So Chhattisgarh was formed in 2000. The High Court came into being into 2000, and it was only 10 years that the High Court was in existence. So there were not a big lawyers in High Court. They were average lawyers in High Court. And many of my fellows, my seniors who thought of joining this profession, they did not do well in the High Court in the field of this law. Can anyone suggest me what is the reason? What could be the reason? Anyone? Try, say something. Yes. No distinguishing factor. Okay. Anyone? Say something. You're a lawyer. You need to speak up. Even if you're right or wrong. This is one thing that you have to learn.
This is supposed to be an interactive session, right? So please feel free to interact with him. Thank you.
See, unless and until you don't speak, I'll not be able to clear your doubts. I'm here to help you out. To help you that what you can do after becoming an advocate or after graduation, what field you should opt. And if you don't want me to clear your doubts, then it is not going to help you. So one of the basic reasons why National Law University students were not doing well that time was because we always keep ourselves above. We think when we are the NLUs, we are the graduates of NLUs, we are in hierarchy. This is a perception which everyone has. And I must tell you, I must confess before you, I also had. Because I was no different. I was not a special student or a special person who thinks otherwise. I was just a part of you. I was you. Few years back. So when they came to the profession, see, this perception of mine was removed by my uncle because he was a senior advocate. I had to work under him. So he gave me left, right, and center. That changed my perception forever. And I had no option to revenge or what, but to accept it. But the others, what they think is that this fellow cannot speak English. How can he represent a case? This High Court is newly High Court. There is no professionalism in this High Court. So what is the point of practicing? But you tell me, what is the most essential thing for a lawyer to have? What is the most essential thing? Logic. Or anyone else? Communication skill. And say, confidence. Learning experience. Okay. The most important thing that a lawyer needs is case. If you don't have case, how will you contest? You can show your skill, you can show your knowledge, you can show anything, but you need a case. Suppose you contest a case. What is one thing that will help you to get case again? Winning that case, okay. Yes, winning that case. Perception of the client, yes. Perception of the client is also important. Trust, okay, trust. See, the first thing that you have to learn is to improve yourself. I practice in Supreme Court. So, Supreme Court, the clients usually do not come to the advocates directly. The cases in the High Court comes to Supreme Court. So the most of the time we get cases from advocates, right? So supposedly an advocate refers to you a case, says, this is the case, you study and tell me what is the, what can we do, whether we can get relief or not. So when you read a case and then you interact with the advocate, the first thing is he'll understand whether you have studied it or not. Second, he'll understand that whether you know the law or not. It is only when he's satisfied in both these aspects, then only he'll give you a case. Okay. So the first thing is study. Coming back to the fact which I started. The second thing is understanding. Understanding will only come when you study. I'll give you an example, and then only he will refer you the case. So you have to be very thorough with both the things. You should have the tendency to read. You should have tendency to apply your mind. See, the law is written. Let's take an example of Article 21. Okay. What is Article 21? Right to life and personal liberty. Okay. So, Article 21 is in two lines. Okay. Anyone knows what is Article 21? No person? Say, come on. No person shall be deprived of his personal life and liberty except the procedure established by law. This is 21. That's it. Nothing more. But you'll see 21 has been interpreted and it has made a huge, there is a huge gambit of 21. Everything will come within the purview of 21. How this happened? This happened because the lawyers firstly gave the interpretation that this is also included. And then the judge accepted that interpretation that yes, this is included. Somebody said that sunlight is my right to life. It is not written in 21. But a lawyer must have interpreted in that way. Okay, it is my right that I should get sunlight. So that is the interpretation. When I was in college, so I was in my first year, and then we had a moot proposition. So the teacher gave me one judgment and said that you will argue from the petitioner side, and my friend was said that you will argue from the respondent side. So we don't know how to prepare the memorial, so I went to my senior and I said that since I am a small town boy, I call everyone Bhaiya Didi. This is what I do. So I said, Bhaiya, tell me how to prepare a memorial. So he said that, how many times you read this judgment? I said, I read it good, 2 times. Well, no, you go and read this judgment at least 10 times and then you'll come to me, then I'll discuss. When I read it in 10 times, I didn't go to him, I prepared the memorial. This is law is, when we read a file for the first time, there's some argument that comes to my mind. But when I read it again, then another argument comes. And when you read it again and again, then your argument skill will change. Reading, you can't run away from reading. If you want to become a lawyer, you really need to develop this habit of reading and interpreting and saying that this could be the interpretation. What is the harm in making an interpretation? You're a lawyer, you have to make an argument. It is for the judge whether he wants to accept it or not. But you have to develop those skills. You know, everyone is aware of the fact of basic principle doctrine. You must have read about basic structure of the Constitution. Keshav Bharti. That is the first thing that comes to our mind. Basic structure doctrine, Keshav Bharti. But you actually know the doctrine was not firstly stated in Keshav Bharti. Are you aware of this fact? Which judgment it was said? Somebody said yes. Are you aware? Huh? Golaknath, yes. To an extent, Golaknath also. But you read the minority decision in Sajjan Singh. There was a Shankari Prasad and then there was Sajjan Singh. You read the dissenting opinion in Sajjan Singh. It talks about, it was also with respect to amendment, the court said that there are certain features of the Constitution which cannot be taken away by way of amendment. Then the law became in this Keshav Bharti. So somebody had an idea that this is my proposition, which subsequently became law. So the first thing I'll suggest you is to read well. Don't just go with the perception that, okay, even if I score, even if I get a graduation degree with back marking, and also I'm going to become a lawyer. You may become a lawyer, but your skill may not reflect it. You may get a relief in a case, but you may not be it may not be good for your long run. That is not going to help you in any manner. So first thing is read. Second is going back to you have to really understand that there are two things that a lawyer is required and that makes him a good lawyer. One is the study. I'm not going to leave this topic of study because I myself was benefited with this. So I'm not going to leave this topic. So one is study. And what is the other one? Anyone? Sorry? Try. I'm sorry, I can't hear you. Writing. Okay, writing. Articulation. Okay. Articulation. Confidence. Okay. This thing will not come immediately, but it will come with time. It will improve with time. Understanding. Okay. Yes. How the understanding will come? Experience. A lawyer who is practicing either in district court or high court may not be very good in English. He is not very fluent in English. He may stammer. And there are a lot of ifs and buts when it comes to his argument. But he has that one thing which you will gain only with the passage of time. And that is experience. There is an article written by Soli Sarabji. 2006 SCC Journal, you'll get that article. And that article, the name of the article is Turning Point of My Life. So in that article, he wrote that he never had a chamber in Supreme Court. So you must be aware that the first thing you'll ask to a Supreme Court advocate is, where is your chamber? But Falias Nariman Saab never had a chamber in Supreme Court. He never had. Why? So he wrote in the article, he said that I don't need a chamber because in my free time, I'll sit in the court and I'll study. I'll read the judge. So this is your experience. So when you are an advocate, you sit in the courtroom, you study the judge. There are 17 bench in Supreme Court, 17 different judges coming from different part of the country, having a different perception altogether. But we cannot have a same pattern of argument before every judge. You really need to study what this judge likes, what he don't like, how you can argue this, how you can argue a matter before the judge. All these things you learn only with experience. So if you are going and joining some senior and he may not be having a very good knowledge like you because you are a pass out of National Law University or a command over language, but he has something which you don't have, and that is experience. So in any case, he knows how to get a relief. Once you get a relief, you will get next case. Then he knows how to get a relief. So mannerism, experience needs to be learned from your senior. Don't, when you go to the profession, when you come to this profession, don't judge your senior. Don't just think that you know everything and you don't know everything. This is one of the major flaw that I have experienced with National Law University students all throughout. Because when a person graduates from a local college, he always give respect to the senior because he knows that I don't know anything and my senior knows everything. But there is a wrong perception which every national law university student is facing, which I also faced, I must say, which I also faced, is that they don't consider their senior as someone who has an experience. And that is one of the factor many of the students from National Law University don't opt for the legal profession, and then they leave the legal profession midway, saying that this is not what we are meant to. We spend lakh of rupees to study in National Law University and we are doing this. Thirdly, you also have to understand that there is a legal and professional ethics which is completely missing nowadays, which you also have to learn before coming to this profession. Many a times I see that the interns are sitting in the chairs and the lawyers are standing. Are you going to do the same thing to your parents also at home? No. If your father comes and he's standing, you are obviously going to give the seat to him. But you don't follow the same pattern in the court. These are the basic things that makes this profession great. That is being followed for years. And now we are not doing it. So you really need to do on this. You really need to work on this. Maybe I'm a third generation lawyer, but that does not make me a good lawyer. There was a tag that I was carrying that, your father is this, your grandfather was this. If you are here, then there is a lot of pressure. You can take the example of, may not be a great example, but you can take the example. We always compare Abhishek Bachchan with Amitabh Bachchan. He may be a good actor, but when you started comparing him with Amitabh Bachchan, you'll say he's not a good actor. He's not up to that mark. So that is the pressure that every what you can say, second generation or third generation lawyer carries with him or her. But at the same time, you also need to understand that this is not an easy profession. When you join this profession, every 2 years, this profession will tell you that leave this profession. Join something else, do something else, get yourself life. But the key is that you have to stick to this profession. Your professional life will go like this. Monotonous life. You won't find anything new. You won't find anything interesting. Then one day, it will go up like this. But to reach to that point where it will go up, you have to be in this line only. So don't take this profession lightly. And there is no harm in practicing in district court. There is no harm in going to the High Court. And absolutely no harm in going to the Supreme Court. Go wherever you want. Practice wherever you want. But follow professional ethics. Read well. Study well. Become a good lawyer. I'm not saying just become a lawyer. That is not going to help you. Nobody will have your name. Nobody will know your name. But when you read well, people will think that, yes, he is a good lawyer. He has some knowledge. If you have any query with me with regard to profession, where you want to start, how you want to start this profession, you can ask me. I'm here to clarify. This is an interaction session, so let's interact with each other. Yes. Yes, see, artificial intelligence is now one of the part of our life. But what we are doing is that we are using AI for the purpose of saving time. That is incorrect. See, I have seen many people, many of my colleagues, what they do is they prepare a paragraph in a matter and then they upload it in the chat GPT and says that grounds for SLP, question of law for SLP. It is going to formulate that question of law and ground. There is no doubt on that part. But what will happen to your application of mind? You may draft it in a particular small time and you will save your time. But when you go for the argument, what will happen? So what you write in the draft, you also have to justify it before the court, right? And then you may differ with me, but you have every right to differ. But I believe that your reasoning, your logic, your skill will be lost if you go completely on AI. See, for searching cases, we were using SCC, Manupatra, right? But when we search a case and we find a case, we read that case. When you read that case, you read the text completely. Don't just skip the arguments for the petitioners or argument for the respondent and also the fact and jump to what has been laid down in the judgment. When you read a judgment, you read the judgment as a whole, because then only you'll understand that what were the facts and how the court has applied the law. If you don't read the fact, you'll just understand the law, but you won't understand how the court has applied. The facts may be different. So even if you are taking help of the AI to do your research, what my request is, don't go completely on AI. Read yourself. Nowadays, few days back, there was a camp in Supreme Court where one of the app-based company, they said that, sir, you pay us 30,000 per month. We are going to work for 2 juniors. We are giving you work of 2 juniors. I said, how you are going to do that? Sir, you just have to prepare a PDF of the High Court file. You upload it, and this app is going to prepare your SLP. That is what the juniors is going to do. So that's how you'll get a help. You'll save a lot of money. You don't have to pay to the juniors. That is okay. But what will happen to the next generation? If the next generation is also going to do the same thing, what is the difference? What about reasoning? What about application of mind? What about the fact that if you thinking that no, we should develop a law on this point, what will happen to that? You may think, you may differ from a judgment. See, you must be aware of the fact that Sabrimala judgment has been referred to 9-judge bench, right? And the hearing is going on in Supreme Court. Are you aware of this fact or not? Yes. So Sabrimala judgment was passed by, earlier it was passed by, okay, 5-judge bench, Constitution bench. Then now it has been referred to 9-judge bench. So there is already a law settled by the Constitutional bench. Why it should be referred to 9-judge bench? Review, that's correct. But somebody applied his mind and said that no, the law laid down by the Constitutional Court is incorrect. That is the reasoning. And you see the argument is going on for days. It will continue till 22nd. Right? If you want to argue for 2 days, can you actually rely on AI? AI cannot give you a speech. That is not a Ramlila Menon कि हमको speech देना है and we have to impress people. No, you need to make your argument. To make an argument, you need to study. Take help of AI. I can't deny this, that that will become an integral part of this profession and your life also in some time. But don't just kill your reasoning. Apply your mind. Read judgments. Apply your mind. Then only you'll be able to do it. See, I was a very, you can say, normal student of my class. I was not a topper initially for the first 3 semesters. Subsequently, I did, but not in the first 3 years. And I was not among those mooters who moved very well and goes to different moot court competitions and participate. I was not among them. But there's only one thing that I followed, that I studied. So when I got a moot proposition, there was a Muslim law moot proposition. I remember I got it in the 2nd year of my university. Then we studied Quran also, because you must be aware that Muslim law is not codified. So when Muslim law is not codified, there is no law. There is no act. All is followed is custom. So we studied Quran also. What is the proposition of law in this? You're a student, you need to read. To come to this profession, you really should be well versed with the legal profession. Otherwise, it will be very difficult, I'll tell you. You may at the initial stage get some case, bail, you may get money, you'll be happy that in the very first year I'm getting money. And from the next years, in the subsequent years, it will be difficult. See, when you join this profession, your senior will tell you how to draft, you'll learn, you'll follow him. But if you do not do the research in your initial stage, at my stage, it will be difficult to change yourself. If I would not have developed a habit of reading, then somebody telling me at the age of 40, you start the habit of reading, it's impossible. That I am not able to take anything from anyone now. So you'll become rigid with the passage of time. So in your initial days, when you join the profession, you do things in detail. Otherwise, in the subsequent year, it will be very difficult for you to change yourself and you will become the same monotonous person who don't read, write, just go upar hi upar se, not in detail. A judge sitting on a dais will understand from the very first word you say in court that whether this advocate has read the file, whether this advocate is well prepared, or whether he actually has a knowledge or not. Supposedly a case comes on the point of constitution. You study constitution thoroughly for that particular case, a particular act or article, let's say article 16, 15. So you'll read article 15 in and out. But when you come to a dais, the question comes from different direction. It may take you to family law, it may take you to the contract, it may take you to the service law. Unless and until you would have studied all these things in detail, you will not be able to argue that point of a law. That is one thing that you have to learn. Please tell me if you have any query. Yes.
Can I repeat the question?
No, I can hear you.
Sir, in the recent time, the Honorable Supreme Court judges has told the students, particularly of the national law universities, that you should go to the district courts first. So is it necessary that we go to the district court, or should we start from the high court if we want the litigation?
See, if I can divide the court, right, in three forms, in three stages. So the first is district court, second is high court, and the third is Supreme Court. So when I talk about jurisdiction, the normal perception that we had is Supreme Court has this much jurisdiction. The court can go into everything. High Court has less jurisdiction. And the trial court has very less jurisdiction when you compare it with Supreme Court. Let's talk about a regular civil case. But do you also think the same thing, same way? Say yes or no, at least say something. No, okay. So what do you think? Every court sums a different person. That is okay. But what about who has more power? Who can look into more things? Supreme Court can look into more things. Is it what you think? Say yes. Arey bas mundi mat hilao. I can't see everyone. Say yes or no. No. See, the answer is no. Because when you go to the trial court has vast jurisdiction. But when you go to the high court, when the matter reaches to the high court, all the document, evidence, everything is being done in the trial court. So the trial court looks after everything and pass a judgment. Then goes to the high court. The high court has less jurisdiction than the trial court. Less jurisdiction in the sense that high court will look into more compact thing than the trial court. The trial court can see everything, but not the like this room. Okay, if it is a trial court will see that those red and black chair. The trial court will see this gray sofa, and the trial court will see this dais also. But when it comes to the high court will say that okay, we'll look into dais and the sofa, because not every aspect the high court will see. All these evidence part, the documentary evidence, the oral evidence will be seen by the trial court. But when it comes to the Supreme Court will see only the high court order, dais. It will not go into each and every details, right? So when you go to the trial court is more of a procedural in nature. The procedure is followed thoroughly. In the high court, the procedural part is less, or I would say the equal procedural part and equally law part, substantive statutes part. But when it comes to the Supreme Court, the issue is very narrow. Like if a clients come to you, whether you have to file a suit for injunction, declaration, specific performance, what kind of suit will be filed, these things will be decided by the trial court advocates. So when you go to the trial court, you learn all these things, that whether in such a situation this particular suit should have been filed or not. But when you go to the high court, there are different jurisdictions. Supposedly the trial court has passed an order. Under which provision it will be challenged? What will be the nomenclature? What is the court fees for appeal? In a criminal matter, whether the bail should be filed, the quashing petition should be filed, whether the anticipatory should be filed, or directly quashing should be filed, or an appeal should be filed. All these things will be decided in the high court. But when you come directly to the Supreme Court, you don't learn the jurisdictional part. Because criminal matter, irrespective of the nature of the criminal matter, SLP criminal. Civil matter, service matter, irrespective of the nature of the jurisdiction, SLP civil. So 136, there is a specific format for criminal, for civil. You just file every case in SLP civil, every criminal case in SLP criminal. So you don't learn what is the jurisdiction. What jurisdiction? Supposedly, an appeal is filed. Then in appeal, the court has to see all the aspects. But when a quashing petition is filed, prima facie, case is made out or not. State of Haryana versus Bhajan Lal. Okay. So that's why the court has said that you first, at least for 6 months or 10 months, go to trial court, learn the procedure. Then you should go to the high court also. I believe if any one of you wants to practice in Supreme Court, then don't just jump to Supreme Court, go to the high court first. Learn something in high court, procedural, and then you'll get more opportunity to argue also. Because in high court, the argument is in detail. You will develop your skill of argument in trial court and high court. That is why the Supreme Court has said. Yes, you were saying the lady was saying something. Yes. Yes, tell me.
Sir, my name is Devjit and I am from first year student.
Okay.
So sir, I want to ask that does EOI of Supreme Court prefer students living nearby Delhi or nearby Supreme Court for practicing under them?
Sit. I'll tell you. See, when you clear an AOR exam, there are 2 mandatory conditions that you have to follow. The first is you should have an office within 15 kilometer radius of the Supreme Court. This is the first mandatory condition. The second mandatory condition is you require to have a registered clerk. So, but so far as the first condition is concerned, you need to have an office within the 15 kilometer radius. So, see, it depends where you are getting your client. If you're getting your client at Noida, Faridabad, Gurgaon, you can live wherever you want. But then many of the ARs also, they are not very regular in Supreme Court. They come to Supreme Court and then they also practice in High Court and different courts also. So it depends where you are getting your work. Living near the Supreme Court or living far from the Supreme Court is not going to make any difference. The only criteria is that you need to have an office within 15 kilometers. Yes.
Sir, I was saying that, sir, students who are practicing under the guidance of senior AORs,
Practicing or interning?
sir, practicing.
That's right.
Means will they consider the students who live nearby Delhi or nearby Supreme Court, or they will consider the students to practice under them living far away from Delhi?
See, a lawyer can practice, a student cannot practice. A student can do the internship.
Yes, sir, sorry for that.
Interns, you want to know about the interns?
Yes, sir, you can say about it.
Whether you are an intern or whether you are a junior, it is immaterial for us where are you living. The point is, you have to come to the court, you have to come to the office. And once you leave the office, whether you are going to South Tex or you are going to Faridabad or Noida, that's your point. So that is your convenience. That is not the convenience of the senior. Right? The only point that a senior will consider is that you have to be on time to the court. You have to attend the office. That is all is required. We will give chance to others also. I'll come to you later. Yes, tell me.
Should we first build depth in law or width? Or for example, sir, we should take a look at many different types of law and then study them in depth, or first we should study, just take one law for example, like CRPC or something, and then study that in extreme depth and then study other parts of law.
You study the way you want. There cannot be any characteristic of how will you study and what will you study. See, right now in which year you are?
So I'm in first year.
First year. So you may have some subjects. You read those subjects well. But apart from that, supposedly if you are getting any moot proposition or you have to make any memorial depending on the subject, then you should, whenever you study, whenever you make a memorial or a project on a particular point or a particular subject, read that point thoroughly, so that in future if any point comes on this, you'll be able to answer something, right? So whatever you have in front of you right now, since you are in first year, whatever subjects that you have, you read those subjects well. That is all I can say. Yes. Good morning. Same here.
So my first question is that, as you've told that it's really important in legal profession as a law student to stand out among your peers. So what should we do as a first year students to stand out in our field? And secondly, if we are very sure about corporate law, that we have to do corporate law, so what should we do apart from law firms internship?
See, that's a very pertinent question. The point is that you have to do your internship well. If you are looking for a corporate, if you're planning that I will join a corporate firm or after 5 years, then your internship has to be good. You have to prepare well for the internship, right? For that, you really need to apply. Your corporate internship, probably the law firms will take after 3 years. They won't take you before that. Before that, you have to complete all those things. And apart from that, you can continue with the subject. You can do diploma courses also. There are many diploma courses that comes. But focus more on getting PPO rather than, I understand that the placement always is a tough task for the college, for every university, because nowadays there are many universities, there are many students. So not everyone get a placement. And then we don't know how many corporate firms will come for the placement. We don't know on that. So when you do an internship well, when you perform well in the internship, then the firm will always call you back, that you can come in the next year also. Maintain good relationships, good PR. That will help you to get good internships. When you do well in internship, the chances of getting PPO becomes more that you can do. Yes. Yes. Hmm. See, your exam, yes, completely. Okay. See, advocate on record is a distinct category of an advocate, as you all must be aware of this. So, the advocate on record pattern was made so that the court can identify the advocates of a particular case. Like in High Court, there are many. If I have 3 of you are my associate, that when I file a case, I'll sign. You will all three of you will have signature. I will also sign. So our 4 of our name will reflect. Then it will be easy to identify the advocates in High Court because it consists of only state. But in Supreme Court, it covers the whole India. It will be difficult to identify a person. Supposedly, a person from Tamil Nadu files a case in Supreme Court, goes back to Tamil Nadu. The other counsel has to file a case. Then it will be very difficult for him to reach. That's why this concept of AOR was introduced. Obviously, it is a benefit. It is one of the steps towards your professional achievement when you're practicing in Supreme Court, that from an advocate, you become an advocate on record. Because only advocate on record can file cases in Supreme Court. The court can identify you. It will be easy for you to get it recognized. So it is, I would say it is one step ahead. It is one step toward the progress of your profession. This is one. Now, with respect to advocate on record, the advocate on record indeed is a very difficult examination for 2 reasons. The first reason is it is of descriptive nature. You need to read and study a lot. This is one thing. But one of the most difficult part for this examination is that you need a practice of 4 years. Thereafter, after 4 years, you have to give a certificate that you will commence your training under an advocate on record who has 10 years of experience as an advocate on record. Then 1 year training, once your 1 year training is complete, then you will have to give the completion certificate, and then you become eligible to write the advocate on record examination. So for you, writing an examination is easy because you're in first year, you must be writing your examination, then you goes in second year and 5th years. But once you are a pass out, suppose I am a pass out, then it is very difficult for me to write. Even if you ask me to write completely in a piece of paper, I won't be able to do it. My hands will shake. The reason is nowadays we are just typing, we are not writing. And we don't write examination. Secondly, when we study a file, we just don't mug up the file. Okay? So if the court asks a question, where is it written? We just turn the page. We say that, Your Lordship may come to page this, 2nd paragraph, 3rd paragraph, 4th paragraph. So it's not that if the court is asking, without looking into the file, I have to tell that in which paragraph, in which page it is written. I can very well refer to the file. It's like an open book examination. So you don't keep things in your mind. So when I started reading for my AOR examination, the first major difficulty that came to me is to retain those things in my mind and then to write in the examination, because your mind has completely changed. It has come out from from a student and now you're a professional. So as a professional, we don't read anything with the object of writing an examination. So this is one difficulty. The second difficulty is that you will not be able to write. So in AOR examination, at least you need to write 20-25 pages. And then you are not able to write only 1 pages because you are not writing for the last 5-6 years. So it becomes very difficult to keep in mind and to jot it down in the examination. So it is very difficult. And then there are 4 papers that you have to clear. The passing marks is 50%, 50 marks, 100 marks paper, passing marks is 50, and the aggregate should be above 60. So even if you clear in 4 examination, but your aggregate is less than 60, you are still disqualified. And if you fail in 4 papers at one go, you'll not be able to write it again. So it is difficult. The 4 papers, huh? See, I came to, no. See, I came to practice in Supreme Court. So once you come to Supreme Court for practicing, you know that this is the next step. Right? So once you decided that you have to be in Supreme Court only, then you really need to pass this examination. Right? Any other question? Yes. I'll come to you after this. Good morning.
To read this particular judgment, or how do we understand that what is more important? Because as a law student, we are met with a vast resource material and study material. So how do we understand?
So if I understood you correctly, you want to ask me how to read a judgment.
Yes, and
And how do we understand it? Right. So you may recall that I told you when you read a judgment, you also read the facts of the case. Okay. So are you all aware of ratio decidendi and obiter dicta? Yes? Right. So what is ratio decidendi?
it's the binding.
The binding precedent, generally what we believe. And obiter?
It's the
Observation. Observation made by the court, not binding. Right? So when you read a fact, you understand what is the issue. So sometimes to give a conclusion on an issue with respect to law, the court has to look after many things and then give a conclusion. So judgment may contain both the parts, ratio as well as obiter. One which is connected to the issue, that is the fact, is ratio. One that is not connected to the fact, a general observation, is obiter. So when you read a judgment, I said you read it thoroughly from the beginning so that with fact you can connect what is the court has held. And you will be able to identify what is the ratio and what is the obiter. But if you read only the part where the court has held something, you will not be able to identify that which is the ratio and which is the obiter. Right? And when you read the argument of an advocate, that sharpens your mind also, that develops your skill for argument, that will help you when you participate in the moot court competition. See, in a moot court competition, you must, I don't know in the first year if you have moot or not, but in moot court, there is a proposition. It's a short proposition. There are different facts that could have been added in the proposition, but the participants are said that you can develop your own facts or argument skill. So all these skill will come only when you read the arguments. Otherwise, you just know the law. It may be possible that you may cite a judgment and refer to obiter. Right?
Thank you. So
Okay.
another question,
Yes.
if you may allow.
No, please.
As a female student, we read this often that female advocates, they feel like there is a certain gender bias in courts. So do you think it is, what is the reality of the courts in that regard? Is there a significant gender prejudice present in the courts?
Till now I haven't faced this. I have not seen this. I can't say I faced this, but I have not seen this. But I must tell you, the fact is that many female lawyers do not opt for hardcore litigation. It is also a fact that we are facing. That is why the court are saying that there should be reservation when it comes to the appointment of a judge. There should be reservation. Recently in the Bar Council election also, Supreme Court Bar Council election that was conducted last year, and this year there is a SCORA election, Advocate on Record Association election, is going to take place on 29th. So the court said that there are posts which are reserved for the ladies, so there has to be an equal participant from the woman, from the lady bar. And I believe that nowadays we are moving ahead, where we want them actually to participate, but then there are situations that may come to their life because of which they drop. But there are many examples of the lady advocates who have risen to the occasion. Recently, Lisa Matthew, ma'am, you must have heard of her name. She is a senior advocate in bar. Now she has been elevated to Kerala High Court. You can see the Aishwarya Bhati, ma'am. She's an ASG. She's one of the leading ASG in the Supreme Court. Archana Dave Pathak, she's also an ASG. So because of her societal structure earlier, obviously we were facing this crisis, but I believe now the situation is not that grim. And then it depends on the state to state also. I must tell you that.
Thank you so much, sir.
Okay. Yes, your question. I'll come to you. See, that's one way of looking at it, but office is a place where you learn the most, because when it comes to drafting, when it comes to research, if you work with your senior will tell you that you have to see this file in this particular manner, then only you'll be able to do research. So for that you need time. 10:30 the court start. Let's talk about Supreme Court. 10:30 the court start. 4 o'clock Supreme Court continues. Okay, so you'll be able to reach your office 5, right? Then you have to do drafting, then you have to do pending box, and then you also have to prepare for the next day. So you need time for that. You really, the safety concern is one of the aspects which may be a cause because of which many of the lady senior advocates are not opting for this profession. But even if you go to the corporate side, if you believe that in a litigating law firm or a corporate law firm you'll get more time, then it's a myth. I don't see that way, and that is also a fact. So even if you join the corporate side or a law firm, it's all the same way. If you want to become a judge, let's say you want to become a civil judge, then you have to stay in office, you have to write orders, you have to sign the orders, you have to comply. There are administrative duties also. So there is no way you can save your time, and if you really need to rise on the occasion, then you really need to work hard. And then it depends on your senior also. If he's okay with the fact that you can go and work back at your home, then it depends on office to office, right? Yes. Morning.
Sir, since your specification is in constitutional law, I wanted to ask, what if you come across a case where fundamental rights are conflict with each other? Also, sir, what is your take on judicial activism and judicial restraint?
Fundamental right.
They conflict with each other, like right to speech and right to privacy. What if they're contradicting each other? What if they're in a conflict with each other?
See, again, I would say that it depends on fact and circumstances of each case. So as you must have studied right to speech, right to freedom of speech and expression, right? 19 you're talking about. But 19 is not an absolute right. It comes with restrictions. But what are those restrictions? When it can be applied? It depends on fact and circumstances of each case. So a right is always followed by a duty, right? If I'm standing and speaking, if I have a right to speak, right to express myself, then others have duties that they should not curtail my rights. If you do not allow me to speak, then whether I will be able to exercise my right? No. So right is always followed by duty. You see, constitution, fundamental right is in which part? Part 3. Right? What is the next part? Part 4. DPSP. What is DPSP? Directive Principles of the State Policy. Guidelines for the state. What is the next part? Fundamental duties. What is fundamental duties? Fundamental duty has come after fundamental right. Why? Because first you are telling that this person has a right. Next time you are telling that in order to protect the fundamental right of this person, you have fundamental duties. And this person who is exercising fundamental right cannot exercise completely. It has some restriction. And what are those restrictions? That it should not affect the rights of other. Like the contradiction you are talking about. Understood? So you have a right to speak, I also have a right to speak. But our right should not be exercised in a manner that it should curtail the other's right. I should not express myself in a manner that I should I should curtail your right or infringe on your fundamental right. But then again, what should be the infringement, what should not be the infringement depends on the fact and circumstances of each case. And the second part was judicial activism and judicial activism and judicial restraint. What do you want me to answer? My view. See, it depends on, again, in which era we are living in. Right? Have you ever heard of ADM Jabalpur case? ADM Jabalpur, anyone? What was ADM Jabalpur? Okay, emergency provision. What was the emergency provision? Sorry? Writ of habeas corpus. Yes. Preventive detention. That's correct. So, correct me if I'm wrong, since you must have studied well. So, ADM Jabalpur says that during the case of emergency, all the fundamental rights are suspended, including Article 21. Habeas corpus remedy is also not available. 32 was suspended basically. So you cannot file a writ of habeas corpus. Right? Is it correct? Then that judgment continued to be in existence for the next 30 years. More than 30 years, I believe. Till Justice Chandrachud overruled that judgment, ADM Jabalpur. You must be aware that ADM has now been overruled. Have you studied? No. K.S. Puttaswamy. It has been overruled. So his father passed the judgment, he overruled it. That was the headline, right? That era has changed. When the court has to reach and when the court has not to act depends on the situation. When we talk about the previous, there was no environmental law. Justice Kuldeep was the one who came out with the entire environmental law through judicial activism. Right? All those task trapezium case, polluter pay principle, sustainable development, these principles came through judicial activism. The court, some may have agreed and said that it is an overreach, but that was necessary. So then again, the court needs to have restraint. Sometimes the court says that it's a policy decision, it's an area of legislation, so we should not go into that aspect. But then judicial activism is also required in some case. Like Vishaka case, you can also say that it is a judicial activism. Or you can say it's an overreach because to make a law, the legislature has power. But whether there was any law to prevent sexual harassment of women at a workplace, there was no law. Vishaka judgment passed in which year? 2005. If I'm not wrong, 2005. The law, POSH law came in 2013. That is after 8 years. But that was required. There was no law. They can say that it will not apply to private institutions or a private organization, but the court said yes, it will apply, right? So then it depends on what the reach. Sometimes it is good, sometimes it is bad also, I must say. Like the Sabrimala case, my personal opinion is that the court should not have gone into the religious practice, because there are something which is beyond our control. If a practice is to be followed in a particular manner, it has to be followed in a particular manner. But that is my view. You can always differ. That is one perception. See, I must tell you, as a law advocate, as a law student, you should keep in mind that if two persons disagree on a point, there is a possibility that both may be correct. Think on this. If two persons disagree on a point, there is a possibility that both may be correct. It's not that one has to be right and the other one has to be wrong. This is my opinion. It's just my opinion. You can always differ with that. Yes. Any other question? Yes.
Like as an advocate, we need to deal with the client. So basically a very long time, like 4 to 5 years in a case, in general, if you see the present time a case name. So sir, what are the necessary skills which a law student should have to become an advocate on which the client can trust? In general, as an advocate, a client will trust an advocate.
See, every client is different. Someone will just come and hand over you file and say that aap dekh lena. And the other one will search in Google and say that these grounds are not mentioned in the petitions. So this skill to deal with the client come with your experience. It will not come in a day or two. When you deal with client more and more, you meet more and more people, then you'll understand how to deal. You may deal it better than the others. But then again, I told you, there are two things that are required for a lawyer: knowledge and experience. That's why I said that never underestimate your senior. He may not have very good knowledge, but he has an experience to deal with the case. Okay? Any other question? I think if you have... yes, tell me.
You said that lawyer thinks corporates
No. No, because see, you can't say that I'm good and the others are bad. This cannot be. Not everyone can become a lawyer. See, it's a tough job. It's not an easy job. Corporate is also a tough job. I'm not saying that going to corporate or a law firm is an easy job. But every profession has its own challenge. Now, saying that I'm facing more and he's facing less is incorrect. Because it is his or her choice. Nobody forced you to come to this profession. It is your choice. And plus, one thing is that this profession, advocacy, is not an employer-employee profession. This is guru and shishya profession. You go to your senior to learn things so that you should be able to stand on your own feet. You don't go to your senior just to earn. If you go to a senior to earn, you will not be able to stand on your own legs. I'll tell you, when I came to Supreme Court, I was practicing in High Court, I was living at my home. So my father told me one thing which I remember very correctly. He said that you were studying in National Law University, we were paying the fees. Now you are going to Supreme Court. So I will assume that you are going for an LLM and I'll pay you. Just don't run after money. Don't think that I'm not getting money. I can pay you for 2 years. That time LLM was for 2 years. So he said, I'll believe that you're going to Delhi for LLM. So I'll pay you every month like I'm paying your salary and your expenses. But never ever run for money. Run for work. If you're getting work, you will get money. Nobody is going to give you work without paying you money. Understood? So saying that the persons who are doing joining LPO or going for bank job or military or anything are bad and the lawyers are great, I don't believe in this thing. I personally don't. Right? I think we are done. Any other question?
Sir, how can first generation lawyers get their cases and chance to argue in high courts during their practicing years?
See, if you work with a senior, he will give you opportunity to argue. And when you get your own case, you argue yourself. How to get cases, that depends on your PR. You really need to develop your PR. There has to be word of mouth that yes, this fellow is doing good. He knows the law. I know it's very difficult in Delhi kind of state, but yeah, in a small town it can be done. I'll tell you one incident. When I was in Supreme Court, I met a junior. She was also from Chhattisgarh. So she was practicing in Delhi High Court. So I asked her, "Arey, how come you are here?" So he said, "Sir, I'm practicing in Delhi High Court." Hello, why didn't you join Chhattisgarh High Court? You're from Bhilai. So she said that, "Sir, there is no professionalism in Chhattisgarh. So that's why I came to Delhi High Court." So then I asked, "Okay, is there professionalism in Delhi High Court?" "Yes, sir. There's a lot of professionalism in Delhi High Court." "Are you getting cases?" "No, sir, I'm not getting cases." What is the point of having professionalism? If you don't have cases, what will you do with the professionalism? The client is least aware of the fact that how did you argue the matter. Client is aware of the fact that whether I get the relief or not. But your skill, knowledge is important because it is the judge who will see and mark that yes, this person is doing good. He will have a perception that he studied. So in some matter where you are not getting relief, if the court believes that yes, he does a lot of hard work, he'll give you relief. Right? Yes. Any other question? So we are done for today. Thank you very much. I hope you must have learned something from me.